Welcome back to City Education, your home for education in all forms, shapes, and sizes. Today we look at a very interesting type of law, mining law. Now, mining has always saved South Africa's economy and land ownership patterns. But who owned the minerals beneath the ground, the landowner or the state? To answer this, we need to journey through the history of mining law and see how the balance between private land, rights, and state power evolved. Now, the roots of South African mining law lie deep in the Roman and Roman Dutch law. The central principle was captured in the Latin maxim, "Quus est solum est usque ad colum ad inferos." Whoever owns
soil
owes it up to the heavens and down to the depth.
This meant that
Landowners were automatically the owners of minerals embedded in their land. In Roman law, minerals were first seen as the fruit of the land, to be enjoyed by the landholder, just like fruits or trees. Later, the law developed to recognize that minerals had emerged public value. Emperors even allowed third parties to mine on private land, provided compensation was paid to the owner. In Dutch law, on the other hand, mining played little role in the Netherlands, but Roman principles were absorbed into Dutch property law. When the Dutch colonized the Cape, these principles were carried into South African common law. So in the early Cape, a landowner had dominion, full ownership of the surface, and all minerals beneath it. This was confirmed in early South African cases like Niebuhr versus Registry of Mining Rights, where the court recognized that freehold ownership included all minerals beneath the surface, and Rothschild versus Registry of Deeds. It was affirmed that unless minerals were expressly reserved, they belonged to the landowner. But even at this stage, there was a growing tension. Mining was too important to be left entirely to private hands. The state began intervening, first by reserving precious metals like gold and diamonds for itself, while leaving lesser minerals such as iron or slate with the landowner. This shift marked the beginning of a long journey from absolute landowner control under common law through a gradual rise of state authority and eventually full state custodianship in the modern era. Now let's start off with the pre-Union mining law. Now, before South Africa was unified in 1910, each colony had its own mining laws. These laws determined how far the landowners could exercise rights over minerals beneath their land and how much control the state could claim it. Let's start off by looking at the Cape Colony. In the year 1813, Sir John Claydock's proclamation introduced the quit-rent system, which allowed landowners to keep ordinary minerals like iron, coal, and copper, but the state reserved gold, silver, and precious stones for itself. Landowners could lease mining rights and charge royalties, but were required to pay 10% to the state. Later laws, like the Precious Stones and Minerals Mining Act of 1883, even allowed the state to issue prospecting licenses on private land without the owner's consent, though compensation was paid for such damages. However, the court still protected landowners in some cases. For example, in Villiers versus Cape Division Council, 1874, Chief Justice de Villiers emphasized that quit-rent holders retained important property rights, though mineral reservations complicated matters. Now, the laws in the Cape Colony ensured that landowners had strong rights for base minerals, but precious metals endowments were increasingly pulled into state hands. Now, let's move on to the Transvaal Republic. The Crown Wet of 1853 declared that unalienated land belonged to the state. If minerals were found on private land, owners could even be compelled to sell or lease the state at a reasonable price. This was an earlier form of expropriation. Moving on, Ordinance 5 of 1866 required royalties to be paid to the state and mandated the discoveries of precious metals to be reported. Now, Law 1 of the 1871 reserved all precious minerals to the state, but respected existing private rights. Later, Law 7 of 1874 went further. It claimed all mining roads for the state, erasing earlier protections for landowners. By 1885, the system softened again. landowners received 10 claims and half the license fees when their land was proclaimed. But the constant shifts created uncertainty. Now in the Transvaal Republic, we can see that the laws were unstable. They were swaying between protection and outright expropriation. Let's move on to the fee state. The Wet Book of 1892 gave landowners freedom to prospect on their own land, while prospecting on state land required a license. The Precious Metal Ordinance of 1904 effectively placed precious metals under state control, even though it did not explicitly say so. For once minerals, landowners retained stronger rights. Under the Ordinance 8 of 1904, their consent was required before anyone else could mine, but the state still imposed royalties. Now, in the Free State, landowners remained the key decision makers for both minerals, but lost significant control over precious metals. Let's move on to Natal. Not all took the most extreme position. All rights based on trespass belonged to the state.
Prospecting
Mining could take place on private land even without the owner's consent. However, landowners did have first preference. They could prospect their own land before others were allowed in. The Natal Mines Act 43 of 1899 shifted this
slightly.
granting landowners rights over specific minerals like coal, limestone, and slate. As we can see in Nadar, landowner rights were the weakest, as the state asserted almost total control. Across all colonies, a pattern emerged. Landowners begin with strong mineral rights under roaming Dutch law, but the state preserves grew steadily, especially for high-value minerals like gold and diamond. This patchwork system meant that landowners' rights depended entirely on where the land was located. It also laid the groundwork for a centralized system after 1910, when the Union of South Africa was formed. Let's move on to post-Union mining law. Now, in 1910, the Union of South Africa was formed. Section 123 of the Union Constitution made it clear all mineral rights held by the colonial governments were now vested in the Union government. For landowners, this marked the start of a long centralization of mineral control. The Land Settlement Act of 1912 reserved all mineral rights in land granted under the Act to the state. This meant that farmers or settlers who reserved land could not claim ownership of the minerals beneath it. The 1917 amendment briefly reversed this, providing that minerals would follow land ownership when alienated.
But the state soon
He asserted control in later laws. Now, this statute meant that even where landowners owned the land, they often did not own the minerals, weakening traditional dominion. Now, the Transvaal Mining Lease and Minerals Law Amendment Act of 1918 allowed the state to grant mining leases to holders of mineral rights or third parties by tender. Landowners received rental as compensation, but royalties went to the state. In essence, this meant that landowners were compensated, but mining decisions shifted firmly into the state's hands. The Reserved Minerals Development Act of 1926 applied across all provinces. If the state had reserved minerals, the landowner had the exclusive right to prospect, but only if they acted. If they failed to do so, the Governor-General could authorize third parties to prospect instead. Now, this meant that landowners were pressured to mine quickly or risk losing rights. The Process Stones Act of 1927 declared that the right to mine and dispose of
precious stones
were vested directly in the state. Prospecting permits could be issued even against the wishes of the landowners. In other words, landowners had no control over diamonds or other precious stones, even on their own land. The Base Minerals Amendment Act of 1942 extended this policy to base minerals. The Minister of Mines could investigate the occurrence of minerals on any land, issue prospecting leases to third parties, and override landowners. Landowners only received rentals and
surface
damage compensation, but lost the ability to block mining. This stripped away the last stronghold of landowner control. In the Turf Estates Ltd vs Mining Commissioner Johannesburg, the court acknowledged that Transvaal gold laws divided rights between landowners, discoverers, and the public, but always to the financial benefit of the state. In Geduld's Proprietary Mines versus Government Mining Engineer, the court confirmed that even private mining required the state's permission, reinforcing the role as a regulator. By the end of the mid-20th century, South Africa had moved away from the Roman Dutch idea that landowners owned everything beneath their soil. Instead, their state was firmly in charge, receiving minerals, issuing licenses, granting leases, and dictating when and how land could be mined. Landowners were compensated for the surface damages or loss of rights, but they no longer had the final say. The stage was now set for the consolidation of the 1960s, when the state would gather the patchwork of mining laws into the uniform national system. Now, during the consolidation era, Parliament consolidated laws into 4 key statutes: the Precious Stones Act, 1964, the Mining Rights Act, 1967, the Mining Titles Registration Act, 1967 as well, the Atomic Energy Act, 1967. The Mining Rights Act, MRA, confirmed that the right to prospect and mine for precious metals and oils was vested in the state, while base minerals often remained with landowners. But in practice, the state controlled operations through licensing. In Geduld Proprietary Mines Ltd, this is Government Mining Engineer, it was confirmed that even private mining requires state permission. Now let's look into the Minerals Act and the foundation of the MPRDA. In 1991, the Minerals Act strengthened state control, allowing ministerial authorization for prospecting and even expropriation of surface rights with compensation. This set the stage for the Mineral and Petroleum Resource Development Act, MPRDA, of 2002. Now, the key changes brought by the Minerals Act include state regulatory power strengthening. Section 3 and 4 give the state the authority to regulate and control all mining operations. Both smelt that no mining could take place without state oversight, regardless of whatever minerals were privately held or state reserved. The Minerals Act also removed classes of land. Unlike earlier laws, which treated state land, alienated land, or private land differently, the Act moved towards a unified framework. This eliminated the old patchwork of laws that favored some landowners. Another affected area was landowners in their rights. Section 5, subsection 1, still acknowledged common law rights of landowners who held mineral rights, meaning they could decide who mined on their property. But this right was no longer absolute. No consent was refused. The Minister of Minerals could authorize prospecting or mining on the land under cessation. Expropriation powers were also introduced by the Act. Section 24 allowed the state to appropriate surface rights to enable mining subject to compensation. This was a significant blow to landowners who could no longer block mining simply by withholding consent. The Act also brought a shift of philosophy. For the first time, mining law embraced the idea that minerals were a national asset to be regulated in the public's interest, rather than a private commodity linked to land ownership. The Act therefore changed the playing field. Landowners lost the final say over whether mining could occur on their land. Mineral rights holders could be overridden by ministerial discretion.
The state
Consolidated itself as the ultimate regulator and manager of mineral resources. These developments laid the foundation for the Mineral and Petroleum Resource Development Act of 2002, the MPRDA. The MPRDA went further. Instead of merely regulating, it declared that all mineral resources belonged to the nation, with the state acting as a custodian. The gradual erosion of landowner control under the Minerals Act was thus completed in 2002.
which
It
cemented
took the shift from private entitlement to national custodianship. The case of Save the Wild Environment with its Director of Mineral Development's 1999 confirmed the Minerals Act's requirement that Environmental and community interest must be weighed alongside mining rights. Holcim, South Africa Ltd versus Prudent Investors Pty Ltd 2010 later confirmed under the MPRDA that landowners had no residential rights to minerals. And there you have it, the history of mining law in South Africa. Now, if you found this video helpful, don't forget to like, share, and subscribe. This is City Education, your home for knowledge in all forms, shapes, and sizes. Until we meet on the next video.